statement, you have the right to remain silent. If you remain silent, I'm going to maintain that you're not guilty, which will reset this for another hearing. But it also could be an indication to me that we're going to set it for trial because you do have a right to a trial. Why is that important? Well, maybe you've had conversations with the prosecutor or the defense attorney about your case, but you do not have to enter into a plea. You still have a right to a trial. You just let me know that when I call your name. The trials are before me, which are called bench trials, unless you make a request in writing for a jury trial. Before either one of those, we'll make sure that you know the evidence against you. At the trial, you can cross-examine any witness that the city calls, and you can have your own witnesses appear. And if your witnesses won't come based on you asking, we will subpoena your witnesses for you. And keep in mind, even at a trial, you still have the right to remain silent. In addition to the right to remain silent and the right to a trial, you have a right to an attorney. It's my understanding that everyone has had a chance to speak with our defense attorney, Mr. Davis. If not, we'll give you the opportunity to speak with him. Or if you want to hire your own attorney, let me know and I'll give you a chance to come back with your own attorney. The pleas that you can enter when I call your name. The first plea, not guilty, resets this for another hearing or a trial. You can also enter a plea of guilty where you are admitting what you're accused of. And if you do that, I could sentence you today. A sentence in a municipal court, such as this one, you have the possibility of a $0 fine up to a $1,000 fine. 0 days in jail up to 6 months in jail. Anything above that is a felony. I'll be addressing the felony shortly. But that's on a guilty plea and a guilty finding. The exact same penalties apply to a plea of no contest. The difference is no contest cannot be used against you in any other proceeding. And then there's not guilty by reason of insanity. That would cause us to stop everything that we're doing to see where you are and your ability to go forward. But keep in mind, the insanity plea is not available for traffic cases because the presumption is that if you're driving, you have the mental capacity to do so. Now, speaking of your traffic cases, a couple things you want to be aware of. One, you want to be cautious of your points because if you accumulate 12 points in Ohio, your license will be suspended. Also, you want to be aware of your insurance because if your ticket is marked no for insurance, the BMV will suspend your license. What I normally do is give you 72 hours to do two things. One, get insurance, come back, we will update the file. That way you don't get suspended. The other thing is, if we resolve your case today and I give you fines and costs, you have 72 hours to take care of that. Or within those same 72 hours, come back with at least $25 and we will put you on a payment plan for the remainder of the balance. All right, felony charges. You have a right to an attorney, you have a right to know the charges against you, and you have a right to a bond. But you also have a right to what's called a probable cause hearing. That's a hearing where the city has to put on some evidence to indicate that a felony was committed in this city and why you are connected to it. They do not have to prove that you're guilty because this is a misdemeanor court. We don't handle guilt or innocence on a felony matter. But if they show me that a felony occurred and that they believe that you were involved with it, then I have to send you to the county because you're not guilty. The county decides the other part of that, whether you're guilty or not guilty. So the bottom line is you will not be decided guilty or not guilty here. It's just a matter of whether they presented evidence that a crime was committed in East Cleveland and they believe that you're connected to it. After you speak with the defense attorney, you have a right to waive that hearing where I would require them to put that information on the record. If you waive the hearing and you have a felony, the big takeaway is you're still not guilty. The case will be sent to the county. I will set a bond. I will even set a court date. That court date will be this Friday, but you're not guilty. All right, let me call the cases that I have, and if you have any additional questions, we'll do our best to answer them. Terrence Watkins, 22 TRD 00166 from January 19th, alleging driving under suspension and expired plates. Mr. Watkins, it looks like your license are in a better position, so the city prosecutor is willing to amend your charge to failing to display your license, which keeps you from getting any points and you don't get additional suspensions. Is that your understanding? Yeah. And then with that, she is going to dismiss the second charge which involved the plate. Is that your understanding also? All right, how do you plead to the charge? All right. So what I'm going to do also with driving under suspension, by it being amended, you don't get suspended, you don't get any points, and your fine goes from $500 to $250 plus costs. But what I'm going to do in your particular situation is I am going to acknowledge that you have this bond here, and any fines that would have been in addition to the bond, because it would have probably been about maybe $350 or so. I'm going to reduce it so that your bond takes care of everything. You don't owe us anything else. So go to the clerk's window, they'll zero you out, and you'll be in good shape. All right. Take care, sir. See, you can get that table off and put it right here. You can just move it in. I forgot it. I just forgot to bring it up here. Kevin Grayson. Mr. Grayson, we have 20 CRB 00510, which is a resisting arrest, and 20 TRD 02366, which is a speeding charge. Madam Prosecutor, how are we proceeding today?
At this time, the officer matter is right now unavailable. So in efforts to just try and speed things along, the case is around 3 years old. I will dismiss the criminal matter and I will offer him an unsafe motor vehicle for the traffic.
All right. So with that unsafe motor vehicle for the traffic, you don't get any points. They marked yes for insurance, so you're in good shape there. How do you plead to that amended charge of unsafe vehicle? All right. I'll accept the plea. It's a $200 fine plus costs. If you need time to take care of that, you're fine. And then most importantly, that resisting arrest in 20 CRB 00510 is going to be dismissed. All right. You just go to the clerk's office and take care. You're welcome. Parrish Simpson, 23 TRD 00570 from September 11th, 2023, alleging failure to maintain physical control of your vehicle, as well as 23 CRB 00356, an open container charge from 9/11/2023. It looks like the city prosecutor, through working with the defense attorney, is going to dismiss the charge involving the open container. Is that your understanding? And you were going to enter a plea of no contest to the charge of physical control. Is that your understanding also? All right. And Madam Prosecutor, just to be clear, you're not looking for any of the penalties that would normally go with an OVI or anything like that, correct?
No, it was never charged.
All right. So how do you plead to the physical control? No contest. All right. And what I have here is that the stop occurred. Again, it looks like it's alleging on 9/11, Orinoco and Allegheny area. They marked refusal to blow, so I have to make sure I vacate any administrative license suspension. Normally when you refuse, they send a suspension to the BMV, but I'm gonna vacate that. And it looks like already stated, so now it's totally vacated. What I'm gonna do, as opposed to the OVI offenses, which could have carried $350 to almost $700, it'll be a $200 fine plus costs. No probation, no jail, none of those other penalties that would have come from it. Just the moving violation. And if you need time to pay, you let the clerk's office know, okay? All right, you take care, sir. Sylvester Primus, the second. 23 CRB 00319. This is an aggravated menacing as well as, it says, prohibitions. You're maintaining not guilty, correct, sir? All right, so we're going to maintain not guilty, set this for October 16th at 9:30. Any questions or anything, sir? All right, you take care. Yes.
That's why I was trying to hold you up. Miss Perry is here and she wanted to be present and she wanted to make a statement.
At the arraignment?
That's what I said.
Yes, she did.
Counsel?
She want to come in the court.
I don't know
That's the one. Like that. So
if that
he need to
is
sign.
necessary, Your Honor. I don't know anything about this case yet. I'd like the matter to be set for pre-trial and any statements that are made to be made if they're at the time of sentencing should come down to that, or she can make her statements about it.
Okay, Madam Prosecutor, so basically we are at an arraignment stage where Mr. Primus is being charged with aggravated menacing as well as prohibitions. Through his attorney, public defender Mr. Davis, Robert Davis, he's entering a plea of not guilty. The normal procedure of the court on an arraignment is not guilty at an arraignment is simply not guilty at an arraignment. Are you asking the court to have other proceedings at this point?
Ms. Perry had a statement that she wanted to make, but it's up to the court how they want to proceed. I understand the regular procedure, Ms. Perry.
Yeah, Ms. Perry, unless the case is one being resolved today, being dismissed today, it's a not guilty. So at this point, it would be premature to make any statements. It's his first appearance, we plead not guilty. The next one, all the evidence that the city believes they have should be presented to the defense attorney. They get a chance to talk. He'll talk to the defendant. At that point, they'll decide, okay, we're ready to resolve the case, or they'll say, hey, not guilty, we're taking it to trial. But what happens is any of the statements that happen prior to that are not helpful for the trial that may take place. So the key is this first stage is a not guilty. And in many of the courts, the not guilty pleas are done in a courtroom where the defendant is by himself. So there's normally maybe not even other people in the court. For instance, at Cleveland, the arraignment court doesn't have victims present. But what I do know is that Ms. McCullough will stay in touch with you so that you're either present at the pretrial in case she's looking to resolve the case at the pretrial so that you're aware of that. Or if it goes all the way to a trial, then obviously you would be necessary and any other witnesses would be necessary for the trial to go forward. You understand all of that?
Yes,
Yeah.
can I respond?
Mhm.
So, on April 6th, the Ohio Crime Victim Law went into effect,
Mhm.
chapter 2930
Yes.
of the Ohio Revised Code.
Okay. Did you have a question for me or?
Yeah, this is part of my question.
Okay.
So, according,
You could stay back there. That's kind of inappropriate. Totally. Defendants at the stage. I mean, we want to keep the court orderly, right?
So, according to, chapter 2930,
Mhm.
point 14.
Okay.
I have a right to make a statement in all public proceedings involving my rights as a victim. And the Ohio Attorney General created.
Okay, so-
Your Honor, the Ohio Attorney General created a different rights request form so that the rights that I have will be summarized. And that, on the request form, it says that I have the right to tell the court my opinion in public proceedings involving release, plea, sentencing.
Who's that, please? Can you stop for a minute and turn your phone off, please? Okay, go ahead, because I'm gonna make a decision based on what you're gonna read to me, but go ahead.
So it says
Mr.
that I have
Pretrial,
the
go
right
ahead.
to tell the court, the victim has the right to tell the court your opinion in public proceedings involving release, plea, sentencing, disposition, parole, and any other hearing that involves my rights.
Okay, so what the court will do is take that into observance, listening to the position of the defense attorney, his position, and the city's is opposite, is that at this point, any of those statements would be premature because it's simply a not guilty plea. So I understand what you've read. It's on the record. I'm going to hold that the hearing for disposition of a plea has taken place. The pretrial, the next hearing is going to be on October 16th. Even then, you can make a statement, but it could be damaging to the prosecutor's case at that point. I mean, I'm sure she talked to you and let you know as long as you have a defense attorney who's maintaining not guilty, every time you make a statement, it helps his case. So, I mean, if you're looking to have this proceed in a way that's orderly so that you can get a good resolution, most times you work with the prosecutor so that she'll let you know exactly when the statement is the best to be presented. But what I'll do is even at the pretrial, I can't imagine at the pretrial where we would go with a statement prior to a plea. I do understand that a plea or a resolution, that's necessary, but at the arraignment, I would hold at this point, I just want it to be a not guilty plea. We set it back for the date of, let me see, October 16th at 9:30. But I do have a record of what you've stated. So it doesn't go without notice, but I am listening to you, the arguments of the attorney. I'm agreeing with the defense attorney that this wouldn't be the proper time for a statement on the case. It's a not guilty at this point. Yes.
I'm confirming that the no contact order is continuing or that you placed one.
So I did not have one. Is that a formal request? Give me 1 second. You understand that, Counsel Davis?
Yes, there was no contact order issued, to my knowledge.
There was no contact order issue. Is there any objection to the no contact order?
No, sir.
Okay. Give me 1 second. So the no contact order, Mr. Premise, means that by order of this court, you can have no contact with the named victim in this particular case. And I think there's an issue with the name in the complaint. Is it more than the complaint has Maddie Perry, but I think there's
Well,
you wanted
that's
it.
her first name, I believe the middle name was before, but I don't know if that's an issue.
Okay. All right. So Maddie Perry, as issued in the complaint, there is to be no contact with her.
No contact order.
I'm sorry.
You already have me on no contact order.
From a prior matter,
Yeah.
I just wanted to make sure that.
So
it would be
so
done.
on this one specifically, let's add it for this one specifically, which means no contact, no social media, no telephone. You can't even send anyone to have contact with her on your behalf. You understand all that? All right.
Can I-
Madam Prosecutor?
Going along with the no contact order, after the last proceedings wrapped, Mr. Freeman suffered a house fire. So at this time, the house really is uninhabitable. However, they are working on it. There, as far as I know, there was construction on it. There are other family members, so I would ask that for the time being, if this is, unless he's like physically living in the house, which he can update, if the house is under construction, that other family members can be there to check on it as opposed to Mr. Prince. I might help keep down something.
Well, at this point, I have a no contact order. If he has a house in his name,
Well,
I can't make
technically, it's in the family name, but he was residing there, but there was a fire, so unless he is moved back in, the construction is complete, he is moved back in, there's no reason for him to physically be on the property, because there are other families.
other than it possibly being his property. I mean, I think that's something to be litigated at another point. Go ahead, counsel.
My knowledge, he is residing there.
Well, I'm not residing there, but I do go there to talk with the constructors as we are building the house from the ground up on the inside.
So the key is you're not living there. So when you are there for discussions with contractors, the no contact means you can have no discussions or no words, no letters or anything to Miss Perry. Bottom
I
line.
don't talk to her no way.
Okay. All right. So that's the key.
One other issue that, this morning he was served with a copy of the civil protection order, so there are restrictions on him placed on that.
Okay. So that would be another court.
They said it was stay away from.
Well, that's fine. This court, yeah, that's an issue from another court. Yours with me is no contact. If there's anything additional on that form, make sure you keep that because otherwise you'd be in contempt of court with that particular judge in that particular court. Yes.
Because I haven't seen that civil
I haven't
protection
either.
order. Usually they have a distance prohibition, and I'd like to know if there's a distance prohibition
Is
as
that-
it relates to no contact. Because if it is,
It's 500 feet. The officer told me that if I'm there and she comes outside, that I have to leave or go inside,
Okay.
which is fine with me.
Okay.
It does say 500 feet if you want to look at it. so.
May I see it, please? You on it?
Yes, absolutely. Just counsel. I'm not sure if you were involved with the other case. There was also an additional issue as to whether or not our victim lives in the house next door. Does she live in the house next door?
Yeah, it's her home, yes.
She lives in the house. Okay.
Well.
Because that's the direct question. It's not is it her home? We just went
It's
through that
her
with him.
home,
Does she
and
live?
She stays there from time to time because she does things out of state and out of
I
town,
have
so.
been, I'm staying there permanently.
Okay. All right. Counsel, you still taking a look at that?
Yeah, please, just a minute.
Give me 1 second.
Maybe it goes to Vince.
Give me 1 second. Yes.
I need the court's interpretation of this because, as I interpret it, and as is customary, because I don't want him to get in any trouble, that he cannot be within 500 feet of her, and she lives at, she's his
Let me
neighbor.
see when.
That's just the same as like no contact order, which the judge says, well, if you are residing with somebody, then you have to find someone else to reside with because you can't be within so many distance. So we need the court's interpretation of that order, civil protection order.
Yeah.
So as to one, so that the judge can give him proper instructions. And so my interpretation of that is correct. And my interpretation is that,
Yeah, it's too close.
Well, right now, my only concern is, it's simple. It's one thing when you're over there talking to contractors, you're not talking to contractors at midnight. So, he
Well,
takes
yeah.
liberties.
So that would be a clear.
Right. This is an ex parte order, so the full hearing is
Right.
November 8th.
Right,
So,
that's the other
you
thing
know,
I was
then
gonna
we'll know
advise
for
him.
sure exactly what all will be ordered.
Right. So, yeah, I'll do my best to advise. Okay, Mr. Primus, let me just address what the attorneys brought up, which is important. So the civil protection order that you were served with, we all agree indicates a limit of 500 feet, all right? You said the police officer spoke with you and told you the best practice is if you are there and Ms. Perry arrives that you have to leave or leave the scene or go in the house. And the order that you received is what's called ex parte, which means you were not present. There's going to be a date when there's a full hearing. I would believe that at that full hearing, either you have an attorney there to represent you so that you make sure that your interests are addressed at that point. And then any question as to the distance could also be addressed. I have no clue, or I can't go into the mind of the person who heard the ex parte hearing to understand why or why not 500 feet was the area that was described. I'm not sure if they had enough information, had all the information, knew your situation there, knew where you lived, where Ms. Perry lived. I'm not sure what they were told or heard, but that was the ruling. So at this point, counsel is concerned just that you be cautious in regard to adhering to the protection order, that you listen to what the officer said, and that when this next date appears, that you appear, so that at that point you can speak on your behalf as to how this order can best be effectuated for both of you in regard to the work that you're getting done there and in regard to your now living there. So at this point, you have that order, you have my no contact order. Any questions about that from you? Okay. Ma'am, you had a question, your name?
Good morning, Your Honor. My name's Morgan Miller.
Just stand up, please. Go ahead.
I'm a victim's rights advocate at
Yes.
Ohio Crime Victim Justice Center. We actually helped pass Marcy's Law back in 2017 and the new House bill as well. We actually wrote the victim's rights request form.
Thank you.
I wanted to address just some concerns as I am here today for our legal director just monitoring the case. Victims now with that House bill do have the right to a support person as well as a victim advocate. And she did want her ex-husband in the room and he was denied entry. So that's just a concern I wanted to bring to your court's attention.
Okay.
And then when it comes to arraignment, victims again do have the right to make a statement, a lot of times it's going to have to do with bond reconsideration, bail, things of that nature. So I also wanted to let you guys know we do free victims' rights trainings as well in case your court would be interested.
Okay. And also just from this standpoint, appreciating that, just knowing the climate of this particular litigation, that's not the first time before the court, even noticing the body language presented in the court, I think at this time it's best to have this matter concluded with the arraignment. Ms. Perry, is there anything else you'd like to state on the record? For me personally, I mean, I'll allow everybody to speak. I'll allow a full, complete record, but then at the end of the day, I'm going to try to make the best decision so that we walk out of here in the most orderly fashion and try to have some semblance of peace. And I will make sure that whomever you need or whomever you want to appear with you is not denied any entry. I'm not sure why that occurred, but we'll make sure that that's done. And plus, at the same time, I'll make sure that Ms. McCullough, or now you're hearing, to make sure you communicate with Ms. Perry so that she's aware of every hearing that you require her, that she wants to be present at, so she's aware of it. You have the new court date that we just set?
No.
Baby Sanders, what date is that again? You got it, Ms. McCullough?
Yes, I do.
October 16th
And she will receive a subpoena.
at 9:30.
You asked me if I wanted to say anything.
Yes.
I just want this to be over. I want us not be called the B word.
Hold on one second. Ms. Perry, go ahead.
I want to not be called the B word. I want my mother not called the B word. I want my child not struck. I want to know that when between 12 midnight and 3 o'clock in the morning, I'm not going to be awakened by boombox speakers because my street is quiet otherwise. I didn't want to be a victim. I wanted to live peacefully in my home, on my street, without a problem with my neighbor.
Okay. All right, Madam. I'm sorry.
Can I go?
Give me 1 second. Madam Prosecutor, anything else?
No, Your Honor.
All right, so just so that we're also, as we conclude, so that everything is totally clear, Ms. Perry, I appreciate that. We'll have you back for your next hearing. And that was your ability to make the statement as to how you feel about the case. So hopefully the advocate is satisfied with that. But again, most importantly, as we leave here, I'm just hoping that in the community that we can all take part in the process of peace. And all I mean by that is, civility goes a long way. For instance, again, we have a no contact order. You have the protection order, so you know not to contact her. On the other end, when you do come into court, if he's standing at the podium, don't just come and stand up next to him as if to move him out the way. There's a way to do that too. Civility goes both ways. I'm going to expect it here on the court. And can I only imagine if it would be difficult in the court, that it would be difficult in the community. So we want to at least start the process here, getting along in this courtroom, being orderly and being civil. Okay. All right. You're free to go. Right. What else do we have? All right. Bailiff Forford, can you stay out there until they're... Can you stay out there with them for a while? Can you stay out there with them until... Okay. Tamika Miller. Miss Miller, we have two cases. 23 CRB 00239 from May 4th of 2023, menacing criminal damaging. And then 23 CRB 00272 from May 8th of 2023, which was a criminal damaging. Counsel Davis, it looks like the May 8th case, you worked with the prosecutor to have that one dismissed. That's my understanding. Is that correct, sir?
I can only say to you, Your Honor, that this lady indicated she wanted to represent herself. She did not want me to represent
Okay.
her.
All right.
So I'm not involved in her case at all.
Okay. Madam Prosecutor, can you give me some details on Miss Miller's case? It looks like one of the charges was going to be dismissed.
Correct. There were two charges that stemmed from an incident involving Miss Miller and Miss Dennis, who was driving Miss Parker's car. So the allegation is that she made threats to Miss Dennis and damaged Miss Parker's car. That's why you have two separate matters. And technically, the damaging should have only been on Miss Parker's case. But in efforts to try to resolve all of this, The idea is that Ms. Miller would enter the first offender program. She has provided her insurance information, which has also been provided to Ms. Parker, so that the insurance companies can pay for the damage, which would likely be more than this court would want to try and cover for Ms. Miller to try and pay it back personally.
Okay. So, Ms. Parker, are you Ms. Parker?
Yes.
Okay, and you're the owner of the vehicle.
Yes.
And who is the victim of the menacing alleged?
Ms. Dennis, she was here
Okay.
this morning, but she had to leave. Everyone has been aware of the offer.
Okay.
They were on board with it.
So Ms. Dennis is okay with the menacing being dropped.
Yes.
And Ms. Parker, we're gonna enter a plea of no contest to the criminal damaging with an agreement to work with the insurance companies to get you paid back for that.
Yes.
Okay, Ms. Miller, is that your understanding?
Yes.
All right. And with that, the other part of it is with the menacing being dismissed, the criminal damaging has an opportunity for you to be in the cycle breaker program, which means once you complete the terms of probation, this would be off your record as if it didn't occur. Is that your understanding?
Yes.
All right. There's a fee for the program. It's $425, but that covers your sealing and expungement of the record and all of that once it's concluded. The key is to work with probation and make sure you get through all of the requirements so that you can get this dismissed at the end. You'll come back before me and we'll dismiss it. Prior to that, hopefully the insurance companies will do their thing to work out. Have they been communicating as far as you know at this point?
I just got her information today, but my insurance is already asking for hers.
Okay. So the day you're going to meet with probation, Ms. Miller, is going to be this Wednesday at 9 o'clock. Will you be able to make that?
I'll have to, I mean,
Okay.
I'm at work, but
Thank you. And what we'll do is we'll make sure that you are,
I just need something in writing to make sure I work for him.
you're okay. Bailiff Warford is going to go contact our probation officer so he can come up and give you that information so that you'll have that. So to the charge of criminal damaging, is it a no contest plea? So I'll accept the no contest plea, but I'm going to hold the finding in abeyance, which means I am not going to find you guilty, but give you the chance to enter the program that we're talking about. You're going to meet with probation on September 27th at 9 a.m. And they're going to talk with you about the requirements in regard to the probation. It looks like most likely what you'll be set up with is with the anger management program to make sure that we just get better tools so that we can express ourselves in ways that don't cause you to come to court. That's the key with that. I'm going to set a 6-month term of probation. And the goal is that you have everything completed by that time. If not, probation could be extended. You could be found in violation and all these other penalties, okay? Any questions at all? All right, have a seat for a moment. When Mr. Medley comes up, he'll talk with you further. You're welcome. Derek Hall, 23 CRB 00333 from August 29th, alleging an assault. Madam Prosecutor, did you just speak with the alleged victim? This is alleging that you pushed a Miss Tolbert, which is the assault. So what I have here is that you allegedly assaulted Ms. Tolbert before we hear a plea from you. And it's alleged that you pushed her. And then the attorneys have worked out that you were going to enter a plea of no contest to this charge and ask to be in the cycle breaker program, which could result in you, of course, being on probation and completing various terms and conditions. There's a fee for the program. But at the end of that program, the case would be dismissed as if it didn't occur. Is that your understanding?
Yes, it is.
Okay, Madam Prosecutor, that's the position of the city?
Yes.
All right. So to the charge of assault, sir, how do you plead?
No contest.
All right. Madam Prosecutor, would you like to make a statement or have the victim make a statement at this time?
She wanted me to speak to her.
Okay.
Both these parties are neighbors. They lived on the same street for years. Mr. Hall actually used to cut her grass. He cuts grass for a number of the people in the neighborhood. So we're not quite sure where this went wrong, because she used to, I guess, look out for the property, because his mom used to be there when he would be at work. You know, if something was going wrong, she would call him or text him. So we're not quite sure where the conflict started. This was just about her having some landscaping work done on the property, and we're not sure exactly what Mr. Hall was concerned about, but he came out and he confronted her. She fussed at him, they fussed at each other, and he pushed her back. And as you can see, Ms. Colbert is a petite lady,
Yes.
older. And so she was very concerned about that, and she has ongoing concerns about whether Mr. Hall's attitude, venom towards her will continue beyond this case, because they do have to continue to live in this same neighborhood. They're like right across the street from each other. So she has fears that Mr. Hall is not done.
Okay. Well, I'm going to hear from Mr. Hall.
I'm just stating what her position is.
I'm just going to hear from Mr. Hall. I know Mr. Hall has to be done because, you know, assault of, you know, a woman in our community is 6 months in jail at the very least.
We have had words. I used to be a real good friend of hers. Everyone on the street had been good friends of hers. She has a temper. I don't know what's going on with her. She assaults everyone. People try to say, even her next door neighbor try to say something nice to her. You're not my friend. Don't talk to me. I've been trying to have a garage built. She had called down here 6 times to the inspector to come and check on everything, to delay my garage being built. I have the contractor, he can testify.
Well, let me ask you this: What are you living on Beersford at this point?
Yes, I've been there for 54 years.
What happened in this particular situation?
Okay, she had a landscaping company out there cleaning her yard, doing her yard. They were doing a very good job. When there's debris on the curb, she had her debris blown away from her curb, and the lady next door, the lady on the corner, just had her yard done. She let them blow the debris all up on her curb and everything. I keep the streets clean, okay? And I confronted, I asked the one guy that was doing the work to, could he blow that away? He went to go blow it away. She went and stopped him. No, don't do that, don't do that. Then I said, well, Miss King just had her grass cut and everything. She knows I keep the street clean. She comes to confront me. Do not tell my, do not talk to my workers, you motherfucker. And that's what I said. What's the problem here? What is the problem?
So, at what point did you place your hands on her?
Yeah, we got a confrontation about it. Words being said. My notion to push her away from was like, get out my face. She had a stick in her hand, went to hit me with the stick. I blocked it. Then she went to hit me in my leg. I turned, and I said, I'm going to call the police. The guy was right there, said, you shouldn't be putting your hands on a woman. I told him, I said, you don't know half of the story. I just went on back home. Just went right up the driveway.
So, question, Mr. Hall. The big question for me is, how are you going to avoid this particular situation going forward?
I avoid her. I tell everybody don't speak to her.
How are you, but you ended up in this situation, so I mean, it didn't work.
Yeah.
How are you going to make sure that there's no physical altercation between you?
Oh, she knows I'm not doing nothing. She used to call me the good son. She knows my meaning.
I don't trust him.
Okay.
Not at this point. I don't know who he is, Your Honor.
Do the two of you live next door to each other?
No,
Or?
Across the
just
street?
directly across the
Okay.
street. But that's
I don't say nothing to her.
So, part of getting the
She don't
case,
say nothing no more to me. After this,
Listen up.
she doesn't say nothing more to me.
part of getting the case resolved, then, especially if we're going to go the route that we're going, will be a no contact order between the two of you. So you can't go across the street to her property. She can't come to your property. No words between the two of you.
That's already.
There's one thing.
Ma'am, go ahead.
Speaking before any of this happened, in 2 years.
Okay. Is there a reason why you weren't speaking?
Yeah, the
That's,
reason why,
that's the
sir,
reason why, that's only within his mind. He never approached me and said anything that was wrong, whether we had an issue, but he never said that. So I took it for what it was worth and stepped back. He cut my grass for 2.5 years. I got a receipt book where I paid him every time he did my grass. When I had to do it for the probate court, when my significant other passed away. He took care of my yard. I paid him 2 years, and then I continued to use him. So whatever issue is within him. And I am 65 years old. For him to come out of his front door and confront the people that are actually, I hired to come and do my yard. He stood outside. They came at 9:30 a.m. They left at 11:40 a.m. He stood on my side of the street all that time, talking to the next door neighbor's son, watching the workers do my yard. And then when they was done, it was 11:45. At this time, the neighbor's son then left. So he went back into his home. The workers was really inquisitive to know, why is he standing here? We've been out here 3 hours almost. Why is he still standing here watching what we do? So he went to his home after the guy parted ways with him next door. He went across the street, went inside of his house, and then when they were wrapping up, I had a broom. I was sweeping. I had a dustpan. I was sweeping, and the other gentleman was blowing everything away. Okay, so he was blowing, and I was already out there with my broom sweeping. He was in his doorway in his house. He came to the door and yelled at the guy, blow that stuff up the street to the park. Blow it up to the park. Blow it away from the lady's house that's on the same side of the street of me. Why any of that was his concern, it behooves me. But then at that point, I told him, listen, you need to stay in your place. We don't speak. You have no concern with the people that I hired to work over here. There's 3 workers, and their statement is they called the police because they watched him come out of his front door. When I told the worker, you don't have to pay attention to him. He's not paying you. Just blow it like I asked you to do, and I'm gonna continue sweeping. He came out of his front door. He was talking through the screen. He walked down his steps. He walked across his yard to me on the street. And he chest bumped me. Then he pushed me. I had the broom in my hand. I was shocked that he did those things. So if I did hit him with that broom, Your Honor, I had every right to. I just don't remember because I just don't. It was hard for me to believe that he came at me like that. And he was wrong. He shouldn't have done that. And I'm 65 years old. The landscapers watched him. The other 2 was in the truck. And they was looking at him. They watched him come down. And they got out of the truck. They said, if you put your hands on her again, I'm gonna call the police. That's when he goes in the house. He goes in the house and then he comes back to the door. They called the police. My landscapers called the police. Not him. He didn't call anybody. And it's all in the police report. So whatever issues he has, I know how to stay away. If you don't want to speak to me and you got an issue with me, hey, I'm not gonna be in your face. I don't wanna be bothered.
Okay.
But then he has something here himself. It's not me, it's him. So I have no problem staying away from him. But at this point, by myself and my dog, I do not trust him. Now, if he can go that far to do what he's done, I'm on medication. I'll go see a therapist tomorrow at 2 o'clock. I take Paxil every night. I cannot sleep. I have to look over my shoulder when I open my gate. But fear, I shouldn't have to live in fear. I shouldn't have to be 65 years old wondering whether my neighbor want to attack me today. So he definitely needs a program, and if this is the best that I could get, because this is the first offense for him in his life, then this is the route that I have to take. So I have to go with what's available. I hope he do what he's supposed to do, But I do have the number from the prosecutor to get a restraining order from the county.
Okay.
Because I can't live like this.
Okay.
Thank you.
Thank you. So this is what I'm going to do, because we're not going to have any back and forth. Look,
Okay.
we're going to have the date that you're going to meet with probation. We're going to put a reminder in your hand. It's going to be this Wednesday at 11 a.m., right? Wednesday at 11 a.m. The fee for the program, $425. We're going to start out with 6 months of probation and give you a chance to finish the anger management program as well as our School of Transformation. Most importantly, no contact with Ms. Torpor, okay?
Yep.
And I do want to say this. And how old are you?
62.
All right, so we have 62 and 65, and she has left the courtroom, but I think it's important for you to hear from me. I wasn't there. It sounds like there's a little bit more going on to this. Like you said, the street may be involved, other people may be involved. I'll say two things that's important. One, I had this conversation, I don't know if I had it with my bailiff or someone recently, about the landscapers that tend to work in East Cleveland. I do find it odd that it is common practice for landscapers to blow debris to somewhere else. I mean, I find that crazy. You're getting paid, you put it in a bag, you take it away. But if you go down any street in this city, they're blowing it all over the place. So that's one. But I'm just saying that because I just want to say that. And hopefully you don't do that. Hopefully you put it in the bag, right? Because that's what you're supposed to do. But the other thing, though, is when it's happening like that, if you're concerned, you call the police, because I'm sure if the police roll up and they see landscapers, that's a form of littering. That's $1,000 fine. Miss McCullough would be great, wanting to prosecute that, because we hit them for that much money. So it's call the police, call the prosecutor, get their license plates, let her know this is what they do. It's not to start arguing with them. And then I'm going to say this. This is very, very, very important. There is absolutely no reason ever for a man, especially your size, to confront a woman, and especially one that size. I mean, there's just no reason at all. We are men. It's our duty, our obligation to exert self-control. I don't care if she's cussing you out from the top of your head to the bottom of your feet, not even a chest bump. That's assault. Luckily, we're in a situation where the prosecutor, the defense attorney, the victim, even though the two of you don't get along, she is not once has she said, "Judge, I want him to go to jail." Because if she did, I would consider it, because all I see is a 65-year-old woman who was chest bumped by a man. I don't care how old the man is, but no one's asking for that. So let's use this as an opportunity to say, you know what? Dodge that bullet. I'm not going to get myself in this situation ever again. If we don't talk again, we don't talk again. But one thing for sure, won't be no chest bumping, right? Or none of that stuff. Yes. That way she doesn't assault you either. And if she approaches you and just starts swinging that broomstick, that's an assault. You know what I mean? That's not allowed. So don't think I'll let that go lightly.
He's been approaching my driveway 2 years ago.
Okay.
That's what it falls.
You got to call the police. Don't take it into your own hand. But
Yeah, well,
but more importantly than that, let me tell you what I really wish. I really hope that at some point we can get peace in the neighborhood, right? Because I am all about civility. Just simply, good morning, how you doing, and bye.
That's what I'm trying to say.
All right, well, that's what I'm hoping to happen. So we're going to set up the terms for probation. Bailiff Warford, what are we doing now? Are we just having them sit down and the marks coming up or something like that? Oh, that's what you're going to come? Okay.
She's nice here.
Call tomorrow. He said, I got somebody right now. So why you didn't see that person in the hallway on the bench and say, I gotta go?
Yeah.
You have to wait for them probation. Exactly. And why you see somebody this morning? Because they have to leave that court.
So what do we do with the first person? Who was the first person? Who was the first person? That went to the mark?
Right here?
Was that you?
No.
So what that person do? Who do we send to mark first?
Her. Miss Miller.
Oh, yeah, so they're both waiting. Yeah. Okay. Have a seat for a moment. You can have a seat. We're going to get the probation officer up here to give you the formal date and everything. All right. So we have Miss Miller waiting, and we have Mr. Hall waiting, and he'll be up shortly. All right. You had a question, sir? Go ahead. Come on, stand up right there. What's your question?
I'm trying to see, like, do I need to get, like, driving privileges or anything? So, like, now, I guess I went down there to see what was going on with my license, and they said that,
I guess they sent it down.
The physical license? Yeah, so what I was told, because remember you were the physical control that was not charged as the OVI. The police took his license. So they may have sent that to Columbus. You say that happens all the time. So your license are not suspended though. There is no suspension. I vacated the suspension. So would he go get a duplicate? This what would he do? Just go get a duplicate. Yeah, that's the inconvenience, is that you have to get a duplicate license.
Okay.
But they're not suspended at all.
Alright, so do I need any document to show the DMV once I get there?
Yeah, there should get a copy of the journal entry so that you have it with you, but there should be no suspension in the BMV system at this point. But if by chance there is, get a copy of that so you can have it with you, or once you figure that out, once the BMV gets involved, I don't know if you know this, but it's a lot of back and forth, ripping and running, so you may have to come back down here, but whatever we have to do to help you out, I will, because there is no suspension.
Alright,
Okay.
Clerk's office will give you that.
Donnie Talley. Mr. Talley, 23 CRA 00375 is a felony charge of receiving stolen property. They are alleging that is a felony of the 5th degree, where you face 6 to 12 months in prison and a $2,500 fine. The allegation is that on or about September 21st in the city of East Cleveland, you were caught driving a stolen vehicle from the city of North Royalton. It was a black Ford with a specific license plate and VIN number. Did you get a chance to speak with the defense attorney about the case?
Yes, sir.
Okay, counsel, on behalf of Mr. Talley.
Yes, on behalf of Mr. Tyler, we are maintaining his innocence, being guilty. He has waived preliminary hearing, and I would, he's unemployed, he's not on probation, and I would ask that he be released on a personal bond.
Okay. Detective?
Your Honor, you have Mr. Talley in front of you, 47-year-old. He lives in Youngstown, Campfield, Ohio. He has an 8 cycle arrest record with receiving stolen property ×2 and theft, Your Honor. We recommend that he has that you give him $50,000 cash with surety.
Is there any movement or room for movement at all? Just
By him living out of the county, Your Honor, we don't know if we're gonna see him again or not. I let the sheriff's department down in downtown worry about that.
Okay.
Your Honor, if I may.
Now keep in mind that his main objection is the fact that Mr. Talley doesn't live in Cuyahoga County. Go ahead.
Your Honor,
Give me 1 second. We'll hear from you in a second. Give me 1 second.
I don't live in Cuyahoga County. I just moved up here.
Oh yeah, where do you live?
I'm back and forth when I'm residing up here in Cleveland.
Okay. Counsel?
Your Honor, this is a felony firearm. And for this detective standing at $50,000 bond on this young man, who's unemployed, has no way of paying a minimal bond, I won't even say the word. I would ask Your Honor again, that if this honor does, if Your Honor does not believe that a personal bond is applicable in this matter, that this young man be placed on no more than a $2,500 cash surety bond. It's not gonna be able to pay that anyway, so, but $50,000.
Your Honor, I hear what the attorney says, but this young man did not give us his address in Cobb County. He gave us address in Campfield, Ohio, which is in Youngstown. Also, he has movement in PA and Arizona. So I think that will be sufficient for us. So once he get downtown, whatever way it goes, we have no jurisdiction over it.
And that is correct, Your Honor. Once he gets downtown, they can raise his bond, they can keep on whatever this court sets, but, dealing 99% of what I do downtown, I can assure you that you're gonna get this man $50,000 bond, people in all likelihood get, a personal bond.
All right, so what I'll do, based on everyone's position, no one's ever happy with a bond that the judge sets, especially when there's no agreement. As opposed to 50,000, considering the charges being an F5, I'm going to set it at 15,000. So I'm going to reduce it. You may not be able to make it out with that amount, but just as counsel said, your court date will be Friday, 12th floor of the Justice Center at 9:45. That judge can give you a personal bond, meaning that's going to be the judge from beginning to end. That's going to be the judge that lets you out of jail, and if you decide not to come back on that judge, in 3 more years, it'll be the same judge. I'm only seeing you for now. So I'll allow that judge to set a lower bond if they see fit. But at this point, I will reduce it about $35,000. Yeah, take it to $15,000.
10%?
Cash and surety,
10%.
Yes, cash surety, 10%.
Yes, Your Honor, before now coming from Philadelphia, before then I'm coming from Phoenix, Arizona, and I just moved back out this way within the last 9 months.
Okay.
And yeah, now I'm out here in Cleveland. I'm just in reside with some friends with Miss Portia,
How long have you been in Cleveland?
3 months.
All right. Make sure when you get in front of that judge, that's going to be your judge, you let them know that, and you have to let the judge know your permanent residence, where the address. That's the only way that judge will feel comfortable lowering your bond, okay? All right, you can have a seat. Good luck. Sylvia Brown. Ms. Brown, 23 CRB 00374 is from September 24th, alleging a domestic violence. That's this year. Domestic violence is a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. But just as important is that if you are guilty of one or you plead to it, the next time it charges as a felony and continues to go up from there every time you're charged. This complaint is stating that on or about September 25th of 2023, you knowingly caused or attempt to cause physical harm by throwing food and punching your child's father. So you've been in jail since, what, one day?
September 24th.
Was it yesterday? Okay. Do you live with your child's father? Okay. Because you understand, when I let you out of jail, there's no contact with him. No calling, texting, hey, I got out of jail, none of that. You just come back to court. You understand that? So it'll be a not guilty plea. I'm going to set your pretrial for October 12th at 9:30. Ms. Johnson, anything additional to add from the domestic violence advocate standpoint?
Not this time, Your Honor, just that he was arrested as well.
Okay.
So I haven't been able to talk to him, but I've spoken with her this morning.
All right, so your bond is going to be a $5,000 personal bond. So I can give you a personal bond because you have to come back to me. Make sure you don't forget your court date of October 12th. And when I let you out, no arguing, fighting, or contact with this person, right? Ms. Johnson?
That was what I wanted to.
Yes. You have the victim's name?
Yeah.
The co-defendant?
Larry Williams.
Larry Wilkins?
Williams.
Okay. Because that was not on the complaint.
Yeah.
Yes.
I'd like to add, she's trying to face a violation of probation.
Okay. So, Ms. Brown, keep in mind, because you're on probation, when you get in any more trouble or new cases, that's a potential violation. So I am going to let you out on a bond right now. You're going to come back on that pretrial date, and we'll go from there, okay? All right, you take care.
You said 9:30, Your Honor, right?
Yes.
He came to us. Yeah.
Okay.
It's another one where he went to Spanish.
To do time? Oh, great. Hey, look at this. Civility and honor.
Looks like we can start East Cleveland Neighbors Court.
We need to. Heather, if you're here past a few months, we need to think about that. Would be groundbreaking because I mean, really.
Because you really don't have that, but you're not the only ones.
Right.
A whole show called Cleveland Neighbors.
So what you gonna do with the Since we only got one defendant, Larry Williams downstairs, we'll do with him.
End up, we'll call him up. Miss Johnson. What can, call him?
But still, what you want to do, then come back.
Stays door to him.
So don't go over there for now until we get this case resolved. Don't go call your mom and have her meet you at your house. But I just want to make sure there's no arguing and fighting between you and him. Okay? Where are your kids? At your mom's house? Yes, do that. You're going to do that today? Okay.
Mr. Bailey is here.
For what? Is that the jail?
At court this morning.
Who is
He
that?
said he came earlier, but I don't know, and then, I don't know, but he's out there now.
You need to go to the clerk's office.
So hold on, Samara. Is the other complaint different?
Court over with.
Is there more violence on the other side, Mr. Williams?
What it is on there is that basically she was over there washing clothes at your mother's house and his house. I think because you got a lot of kids on there. She was using both of them.
I thought this case was over.
He offered her some food, but when
The
the guy
Marine.
came over and started talking to her neighbor that they knew, and they went in the house, he got upset. She wouldn't fix the bowl anyway. And he tried to grab the bowl and it flew over. That's her version.
Okay.
His version is she was standing there, started getting the bowl of food or whatever, and threw it, and then they got into an argument, and then she threw it on him. So I don't.
Did he strike her?
It was said, she said that he struck her.
Okay.
He said that she struck him first, and he did strike her after, so that's why they both was arrested. They couldn't tell which one was actually
Okay.
getting it, but they've been here.
What kind of
A few times. Okay. They've been there a few times? Okay, in that case, he could sit for
Was it
a
you?
day.
Or you being funny? Oh,
You got space down there for him to sit for a day?
oh, yeah.
Okay, cool. Because I'll probably Williams.
Oh,
Unless you-
Well, we're gonna,
I
gonna
think
release
it's gonna
him?
be a felony.
we send him downtown.
Because of his DV history?
Yes.
Yeah,
Okay.
we send him downtown.
Excellent. All
So
right.
downtown, some
Listen, Judge,
all the food
I
I
don't
found
like
on.
to put enough on you. You got enough already.
Well, you know what else? We only have one defense attorney right now. So when we have double defendants now, we got to figure out how to work it because
Guess what?
Jocelyn,
You got the best.
I got the best. I'm sorry, you need something? I didn't mean to ignore you. What?
$1,000.
So what's Mr. Bailey about? What was this case about? Do you know? I haven't seen the file. Is it a pretrial? Is it a...
Don't give me the line, I don't know.
Nobody knows?
I don't know who Mr. Bailey is.
I mean, look, who is Mr. Bailey?